swear, didn't nothing confuse and frustrate the shit out of me more than this when I was fighting my child support case. Emerald signing in, people. Before I get started, make sure you go ahead and like this video. Share it if you know, for people that don't know, don't know about the channel, the channel, and we're trying to get the stuff circulating around the internet. Okay. All right, y'all. Failure to state a claim. I swear, when I was fighting my child support case, I was kind of clueless as to what they really meant by it. To me, it was kind of self-explanatory, but it really wasn't. Especially when, it probably is now to me because of how I, my level of knowledge now. But that was my very first case I ever took on by myself, no attorney, trying to do my own paperwork, not knowing anything about the legalese. I knew it existed, but I really didn't know. I knew that it meant something that it really, anyway. Failure to state a claim. A defense asserting that even if all the factual allegations in the complaint are true, they are insufficient to establish a cause of action. And you'll find this in the Federal Rule of Civil Procedure at 12B6, as you can see right here. If you look this up, you'll see this one of the defenses when someone actually brings a claim against you in court. And, it's a defense you can use against someone who's actually bringing a claim against you, and vice versa if you're bringing a claim against someone else and they use this on you. They're basically, I was confused as to what they meant by that. And I'm like, hell, the petition, I'm making a claim right here with the petition. I just said you did this. I just said you did that in writing right here. This is the claim. And I was thinking the petition itself was the claim. And of course, it's not true. So you need more than just the petition. Let's go through with that. Let's go through it. I'm going to break this down. I'm going to start out with failure and then to state, and then we're going to look up claim. And I'll be using the Bouvier's Law Dictionary. And I'll also be using this right here that you're looking at right here is from, Cornell University. Okay. You can find this just by Googling. Okay. And I'll also be using the Black's Law Dictionary, probably 2009 version. And let's go ahead. Let's proceed. Here we go. We're going to start with failure. Failure right here, as you can see, Bouvier's Law Dictionary says a total defect, an omission, non-performance. Say it's a non-performance of some sort. Okay. And which means it's something I left out. It's something I failed to do in my claim, to follow up with my claim. It's something that I failed to do. It's something I left out. That's what omission is. An omission is something you left out. And I had no clue. What was it that I left out? And now let's move forward. I don't want to drag this video out. I just want to kind of keep it brief, but at the same time, keep it straight to the point. But at the same time, I want to make sure y'all understand. If you don't understand, some of y'all probably already got this. But me, myself, I didn't get it when I was first starting. So if you're a beginner, you probably won't get it, from the start. Some of you will, some of you won't. But here you go. That's the beginning. We already know that's pretty much about the same thing, but legally, that's what it means, the same thing. It's a non-performance. Okay, now we're going to go to the next part. To state. This is Bouvier's Law Dictionary as well. It says to make known specifically, to explain particularly, as to state an account, or to show the different items of an account, to state the cause of action in a declaration. That actually speaks volumes now that I'm teaching a lot more on trust law a lot. So y'all see, this is where I'm going with that. I'm trying to bring it all together, so to speak. I knew nothing about trust law in the beginning. I knew absolutely nothing about it. I heard about it, but I didn't know shit about it. So I wasn't trying to teach about it because I didn't know nothing about it. Even back in 2019, when I had my old channel, I didn't talk about it, as y'all noticed, because I didn't know enough about it to be talking about a trust. Okay. But here we go. I'm trying to tie this right in. See, the state say to state a cause of action in a declaration. That actually reminds me, since I'm going back looking at this, a declaration it's like the saying. It's basically, it means to declare something. You're pretty much you're making something known. Okay, you're making something known, and the easiest way to make that known is basically you're recording it on the record, you're putting it in the newspaper or whatever. You're making it public, making it known to the world that this is what it is. Okay. So I'd like to take a moment to look at an indenture, because most people probably never knew what an indenture was. And if you look at an indenture, it's pretty much like the same thing you'll find in a certificate of trust or trust itself. The trust itself, you'll find it. Now let's go back. Let's go look at that word real quick, and then we're going to look at claim. Okay. Here we go. Trust indenture, 2009 Black's Law Dictionary. As you can see right here, a document containing the terms and conditions governing a trustee's conduct and the trust beneficiary's rights, also termed indenture of trust. See deed of trust under deed. So as you can see, when you create your trust, if you create a trust, you're going to state who the beneficiaries are, who the trustees are, what the trustees' powers and restrictions are. That's basically what that part is actually the trust indenture. The part that talks about what the trustee can do and what they can't do. That's basically what this is talking about, the trust indenture. You may not have trust indenture written in there to separate the powers of the trustee. You might put on there trustee powers or trustee whatever, but it's technically the trust indenture. That's exactly what it's almost like the constitution of the trust. Okay. I hate to use that word constitution, but you get it. Same thing with the trust does for the United States. The trustees, the public officials are bound by the constitution of that, of the United States trust. And, anyway, you get it. Y'all get it. Okay. Now we're the beneficiaries of the straw man. Okay. Now, so the trust indenture, as you can see, it can be seen as a deed, and you record deeds in the county recorder's office most of the time. In most states, it's going to require you to do that. Let's see. So this is one of the main reasons you have to, in most cases, you have to record a certificate of trust or a declaration of trust, whichever one you want to call them. To me, they're about the same damn thing because they say the same thing. And if you look in your state statutes and you type in a certificate of trust, it tells you what the trustee's power, it tells you what has to be in a certificate of trust in order for it, that's what's required by state law for the certificate of trust to be, valid. So, and in that it's going to tell you, you have to basically state in there what the trustees can do, which is pretty much the indenture, which is also known as you see deed of trust under deed. So technically a trust indenture is a form of a deed, which is to be recorded in the county recorder's office. Now don't get confused because some states don't require you to record a certificate of trust in your county recorder's office. But you can still use one when you're trying to move forward in a case. You can file it into a court case, or you can actually, present it to, in a bank when you're trying to open up a trust account. You use a certificate of trust. You're using a certificate of trust with your ID or whatever to open up a trust account. Anyway, it's what you use it to keep your actual trust instrument private. You don't show the whole trust unless, under certain circumstances, you trust that you would show it. But generally, you would use a certificate of trust as a substitute, more like a summary, like a small summary of the actual trust. So you can actually get things done without making your private information public. Okay, so you're sitting here using that trust. You can actually use that if you're operating in trust with concerning a court case. You want to use your certificate of trust to prove that you're actually operating as a trustee. That's it. I'm saying a trustee for your own trust. That's if you appoint yourself as a trustee in your private trust that you create yourself. And then, you're operating in the trust. You actually, I want to watch how I'm saying this because I don't want to confuse people that are just getting started on this. Say you create your own trust. You name it whatever you want to name it. And you make yourself a trustee. Okay? You can make whoever you want to the trustee. It's your trust. Okay, you make whoever you want the beneficiary. That's totally up to you, depending on what you're trying to do. Okay, and say you're operating under, and you're operating in trust, using the trust itself in the court case, and you're basically pretty much letting them know that they don't have jurisdiction over your trust or whatever, over your straw man. Because I'll say if you got your straw man inside your trust, you can actually use that certificate of trust to prove that. Okay, and then that will go back to my original topic, where we have claim here now in Bouvier's Law Dictionary, 1856. I don't know why I'm using 1856, but anyway, it's still valid. Okay, a claim is a challenge. It's a challenge of ownership of a thing which a man has not in possession and is wrongfully withheld by another. And so you basically, failure to state a claim, basically means you just failed to actually prove prove what it is that you're trying to say in your petition. That's basically what it means to, when failure to state a claim by which relief can be granted. Basically, you didn't put any evidence with your claim, with your petition. Notice in a child support claim, well, not a claim, but a case, whatever you want to call it. You notice when someone brings, like I said, a child support case against you, and and you're in there, you look at the petition, you see the opposing parties' information attached to the petition, like they got financial affidavits and whatever it is that they're claiming that you did, or whatever it is, whatever allegations they got an affidavit or something attached to the petition, and basically to try to prove what it is that they're trying to say. And it could be false information. It could be a false claim, but they still have an affidavit attached to it. Your job is to rebut whatever it is that they have in there, But anyway, that's another topic. But if you're bringing something against them and you don't have your evidence attached to your petition, then that's when they're going to respond with failure to state a claim, by which relief, because you can't get relief if you don't have any proof to back up what you're saying they did to you. So that's in simple terms, that's what it means to failure to state a claim by which relief can be granted, for which relief can be granted. So that's exactly what it means. You need to have some evidence attached to your your petition to prove what it is that you're saying. And I never knew this is what the attorney meant when he kept doing that to me. And here I was just stating things, and I was stating it based on what's common sense pretty much. But if I had nothing on the record to prove it. And this is not just for trust law. This for anything that you're using, anything that you got going on in any court case you got going on. You have to have evidence to prove what it is that you're saying. So it's not limited to trust. Okay, so if there's a straw man versus a straw man, and there's someone saying that you say you're saying you damaged their property or whatever, and they don't have any affidavits, no proof or nothing attached to that petition. Is just an empty claim, but there's no evidence to back up what they're saying. You could use this defense to kill the case, because they have no proof of it. There's no evidence, and from that point, they're going to have a hearing or something, or shut it down or whatever, to give them a chance to prove what it is that they're saying. But anyway, I don't want to drag this video out. I thought I'd go ahead and point this part out, because I've been wanting to do a video on failure to state a claim for a minute, but I kind of put it on the back burner because I understand it now, and I figure most of y'all probably do too. But hell, you never know. So make the damn video and make it anyway, just in case some people don't know what it means. Okay. All right, y'all, I'm going to get on out of here, y'all. I'm going to catch y'all on the next video. Don't forget to like and share and to subscribe if you have not subscribed already, because I got more coming. All right, y'all, hold it down. Emerald signing out.